Good morning, Your Honors.
Good morning.
John Barnes of the Knoxville Bar here for the appellant Leslie Hurn. If I could reserve 3 minutes for rebuttal.
Sure. 3 minutes.
I would first address the stipulation issue as this court ruled in Faust. We have nearly the exact same situation in the same trial court on similar charges where an individual facing gun charges with the enhancers for either violence or a deadly weapon, it's objected to at the trial court level that the substance of those prior enhancing crimes come in. And the court talks with defense counsel about the possibility, and this is where it's a little bit different than in Faust, of severing the gun charge from the others. And in this case, he did do that. So the court severs, but the parties from page 8 to 24 in the transcript have extensive conversation about what that means for this defendant and what it means for the evidence that's going to come in over the course of the case. And it becomes entirely evident that at no point during the discussion of the stipulation, whether it will be entered, what its content will be, were the parties ever on the same page. You've got defense counsel, even after agreeing that the defendant will stipulate, asking the court, so which one of the 5 prior convictions are we stipulating to? And the court, this is after a significant discussion of that he would be stipulating to a particular status that would satisfy the enhancement. Even at page 24, this is the very last, defense counsel has no idea. And it's not just defense counsel, it's counsel for the state as well. We have that individual, that lawyer, after this break, so they take a break and address some other matters, reports to the court that counsel for the defense and the state are not on the same page. We know from Faust, and what this court said was, this requires mutuality of agreement, it requires voluntariness, and it requires the court not be involved in determining what will be stipulated or whether a stipulation would enter.
So, Mr. Burns, help me with the stipulation issue. Is the complaint with the fact of the stipulation? Is the complaint with respect to the language of the stipulation? Both, or is there another option?
It's with respect to the fact of the stipulation, okay, in that the stipulation never would have occurred except for the court's significant mediation, I would say direction, sure, almost to the point of ordering. And so when you go to page...
So help me with this. The stipulation itself is, I read the record, the idea of the stipulation arose first with defense counsel. You weren't trial counsel, as I understand it.
That's correct.
It arose first with trial counsel when she says, Judge, we can stipulate. Now, it looks to me like the trial court judge and defense counsel are talking past each other, at least a little bit, but it looks to me, and this is different than Faust, it looks to me that defense counsel was the one that suggested the procedure for stipulation.
I think defense counsel at the very beginning is the first to say the word stipulate. Okay, it doesn't get much further than that. You know, the court is talking at that point about severance or bifurcation, and that's page 8 through about 16. It
is, and so once the court then severs the third option there for the state to prove up the element, it looks like trial counsel was the one who proposed the stipulation to avoid the judgments coming in. Is this a situation like Faust where the trial court is essentially trying to force the parties into a stipulation? Can the trial court not be helpful in suggesting language?
It can, and I think the way the trial court conducted, not itself, but conducted this particular legal issue and thought about it in those first few pages and with the severance, if that's all we had here, that's fine. But then you get to after the break, and after the break, defense counsel has no understanding similar to that of state's counsel. And even then, the trial court can be helpful in saying, you know, what the court, I think, told them in Faust was that this has got to be a matter for the parties. It can't be a matter for the court. And when you look at page 16 through 24, it becomes a matter for the court. There are 3 parties negotiating the stipulation. not two.
So what's the remedy that you're seeking then? Because it seems to me that the remedy that you're seeking, if we don't take issue with the language of the stipulation, which is just that the defendant has a qualifying offense, are you seeking a new trial where the state goes back and introduces the certified copies of conviction, judgments of conviction?
That'd be a decision for trial counsel at the time. You know, these particular enhancing prior felonies are elements of the offense.
What relief are you seeking from this court? Are you seeking a new trial so that the state can go back and introduce the certified copies of the judgments?
A new trial, and for defense counsel at that point, a stipulation could be entered, but it has to be a legal stipulation that is negotiated between the parties because this is an element of the offense. They removed the state's burden by entering the stipulation in such a way that is in contradiction to Faust. The state has removed an element of the offense, and therefore a new trial is required.
So trial counsel did not object to the language of the stipulation.
The language is not what's at issue. And
so the language, appropriate language then, goes to the jury for the jury to consider. Where's the error?
The error is...
How about this? Where's the harmful error?
The harmful error is in that, as I was saying, this is an element of the offense. And so if this was entered in error, if there was significant, what was tantamount in my mind to an order of the trial court to remove one of the elements, the beyond a reasonable doubt element from the defendant, that's the error. And so at page 21, we finally get to a point where this is where I would identify what was tantamount to an order came down. The court says, we're just going to put in a stipulation that Mr. Hurn has a prior felony. And then the state, I think in its brief, suggests that, well, this was the state that drafted this, but even further down in the same page of the transcript, you have the trial court who says specifically, state, I need you to draft this stipulation. This is what the stipulation needs to say. I mean, he goes as far as to nearly word for word say, this is what the stipulation is going to be. And that's after acknowledging the Faust ruling. I mean, he was aware that the court can't be involved in, it can be helpful, but it can't be involved. It can't be a party. And it was tantamount to a party in this particular case.
And then after all of that occurred, and that my reading is the same as yours, after all of that occurred, though, defense counsel said, we stipulate on the basis of the stipulation proposed.
She said, we stipulate, and then a page or two later inquires to the court, what have we stipulated to? You know, which one of these 5 prior underlying, and so that just demonstrates, I think the court said in Faust, that the lack of mutuality was illustrated by the prosecutor's confusion and request for clarification. That happened numerous times in this particular transcript, but importantly, it happened after the defendant's counsel had said, okay, we stipulate, and she's still demonstrating confusion and request for clarification. And that's exactly what this court said in Faust made the stipulation improper, was that there was no mutuality, and without mutuality, this can't be a voluntary stipulation that removes a particular element of this offense from the state's burden and from the jury to decide.
You mentioned bifurcation briefly a few minutes ago. Did trial counsel ever suggest that as a potential option following the severance? Bifurcation of this particular count?
She advocated for bifurcation prior to the court severing count 3. I think that was her preferred method, was to bifurcate, and the trial court either didn't believe it had that option. That's what it sounded like, that he didn't think that he could bifurcate, although I think he could have.
Well, there's no reason to bifurcate after the severance.
Well, this was before.
Yeah, but once the trial court severs, though, count 3, there's no reason to have a bifurcation.
There's nothing to bifurcate.
Okay, that's right. Okay.
Yeah. I don't think it makes a difference necessarily to the outcome of the particular appeal, but she initially asked for bifurcation but got severance, was my understanding. The trial court also, on the morning of trial, was presented with 2 motions, a motion to continue and a motion to suppress, and he questioned the lateness of the filing of that, and the state picked up on that in its brief. However, he did not deny the motion based on the lateness of its filing. I think the first time that really ever came up was at motion for a new trial when he said, well, you filed it late anyway. But there's no order in the record on the motion to suppress. There's no order even in minutes that says, this was late filed, I'm not going to consider it. What happened was it came up in pretrial motions, as motions do on the morning of trial often, and he addressed it. And the way he addressed it, he said, well, what difference does this video make?
Wait, you say motions come up on the morning of trial as they often do?
Maybe not motions to suppress.
Okay, that was
But
going to
in
be
this
my next
case,
question.
some motions to suppress, not typically, but when the trial court endeavors to address this motion, which I think he did, and does not rule, other than to say, no, we're going to trial today, that was the only ruling, he effectively kept the motion from being heard. There was no findings of fact. There was no testimony taken. It's a fact-intensive motion. This is a warrantless seizure, which is deemed unreasonable. And so how does this court go back and decide, okay, how are we going to rule on this suppression issue? There's no findings of fact, and the state says...
Isn't that why it should be incumbent, though, and I'm sorry to interrupt, but isn't that why it should be incumbent upon trial counsel to file this important motion earlier than the Tuesday before the trial?
I think so. I think it probably is, and be disingenuous to say otherwise. However, this is an important right of the defendant, and the trial court, if that was its ruling, could have made that ruling. It could have said, I'm sorry, Ms. Lee, you filed this a week ago. I'm just not going to consider it under our local rules. It's not timely filed.
Well, for all intents and purposes, though, isn't that what the trial court did? I mean, they didn't take proof.
That's what it said in the motion for new trial, when it denied the motion in the motion for new trial. It said it was untimely.
Which was not the ruling any time prior, and the motion for new trial was 3 years maybe after. And so when you read the transcript, there was a de facto ruling, which was, we're not having a hearing. I'm just going to deny this motion.
So let me follow up on Judge Hickson's question, because it's an important issue. So Judge Hickson's question is, shouldn't trial counsel have filed the motion prior to the Tuesday before trial? Maybe more fundamentally, does trial counsel have an obligation to demand a ruling from the trial court, or to ask to be heard, to ask for a hearing? And so, as I read the transcript, once the trial court says, no, we're going to trial today, there was no objection that was made to that. Trial counsel did not say, Your Honor, respectfully, I ask for a ruling on my motion. She did not say, Your Honor, respectfully, I request a hearing on my motion. None of that was raised by trial counsel at all. And so what do we make of the fact that she filed a motion, but she never requested a hearing? She never objected to the ruling of the court.
When, prior to the trial court saying, no, we're going to hear this case today, there was discussion, there was argument. I mean, there was an argument between counsel and the trial court in discussion of the merits of this suppression motion. Because the trial court's saying, well, wasn't he already seized? What difference does this video make? So he apparently agrees that there has been a seizure, a warrantless seizure. So we're talking legal argument at that point. And it cuts the entire thing off. And so at that point, if you are defense counsel, you have been heard to some extent on your motion, and maybe the better practice is to say, no, I'm going to stomp my foot right here, and we need to have a real hearing.
You think counsel has been heard on the motion?
I think there was argument on the motion, and that it was...
That's not your position here in this court, though. Your position in this court is that she wasn't heard on the motion.
I think she was denied a right to a hearing on the motion, but once you are speaking with a trial court, he's considered your motion, he's talked about the legal merits of your motion, and says no. He has de facto just said, we're not going to have a hearing on this, and it's a denial of your right to have that motion heard, and particularly a denial of your right to have an appellate court decide this important issue that would have been the end of the case.
Well, first of all, going back to what Judge Greenhalgh was saying, is it would appear to be that if this was so critical, that the defense counsel would have immediately, voiced an objection or stated that we're demanding a hearing, that this needs to be heard. Why, Judge, I want on the record for appeal purposes why you're not allowing us to have this hearing. Because otherwise, as it appears in the record, there was no objection after that. Everybody just went on to trial. And then at motion for new trial, the judge then says out, look, this thing just wasn't timely filed. And it is a frustrating thing when something is so critical, this critical issue that we have to have heard, doesn't get filed till like less than a week before trial. I mean, it sure makes it look like it was just a kind of a CYA thing. We're going to just put this in there so I can say I did it. But if it was critical and if it was an issue that was going to be litigated later, doesn't defense counsel have an obligation to clarify that issue for the appeal?
I think defense counsels, there may have been failures there, but I think defense counsel needed to understand Rule 12 and what was required of the trial court and demand that. But even equally so or more so, the trial court needed to understand the strictures of Rule 12, B and E. And when this motion was made, the court has an obligation to follow Rule 12 in some capacity. I mean, there was just nothing done whatsoever, and so
The court does, or does the movement?
You're running into your rebuttal time, so I just want to...
thank you. I will. I'll answer Judge Hickson's question first.
Yeah, we'll credit you the time on this since I'm actually the one going over. Is it the trial court's obligation or the movement's obligation to get that not only filed, but filed in a fashion where they can get it docketed and heard? I mean, we can't expect trial courts to peruse the records of all these cases and say, oh, I need to get these parties' motions heard. Isn't that the party's responsibility?
It's the party's responsibility up to the point that on the morning of trial, the trial court takes the motion under some consideration, speaks about the motion. At that point, it's being considered, and so it needs to be heard. It would have been perfectly legal and proper for the trial court to say, I'm sorry, trial counsel, you filed this way too late, it's denied as untimely, regardless of how excellent your motion is and whether or not it ought to be granted.
Judge Campbell, can I ask one question just very briefly? Counsel, in the sufficiency of the evidence argument, it looks like that argument relies heavily upon the stipulation itself being proper. If the court were to conclude that the stipulation were proper, is there another argument that the evidence would be insufficient for conviction?
There wasn't one.
Very good. Thank you. I appreciate it. Thank you, Judge.
State?
Good morning, Your Honors. Abigail Renard for the state. This court should affirm the defendant's conviction for two reasons. First, the parties suggested the stipulation, negotiated the language, and voluntarily agreed to it. And second, the defendant waived his suppression claim by failing to request a hearing or argue it before the trial court. To the extent there was any error in not holding a hearing, it was harmless.
So, General, how do you distinguish Faust?
So Faust is a very different situation because the trial court did not bifurcate or sever. The defendant requested bifurcation or severance, and there were multiple other charges going on. There was a lot more going on in that case. And I believe in the, so there were two Fausts, and in the first one, they actually told them they should have bifurcated, come back for the second one, and defense counsel again requests bifurcation or severance. The trial court denies it. Defense counsel continues objecting the entire time and just basically got denied the opportunity to have any sort of discussion about it. And then the trial court actually ordered them to, and I believe expressly said what the stipulation should read.
Well, I mean, the appellant in this case says that's exactly what happened here, right? Is that although the initial stipulation was made by, offer to stipulate, concept of stipulation was made by defense counsel, at that point, really the trial court is taking over. This is the appellant's version of the events. And so that the trial court is insisting upon a stipulation, it's insisting upon the language of the stipulation. Just as in Faust, counsel doesn't object, but counsel in Faust didn't object either. Counsel in Faust actually said, fine, we'll stipulate to this. And yet this court still found error because of the involvement of the trial court in that. So how is the involvement of the trial court here? And I know the trial court was very sensitive to Faust in the hearing, and
Yes.
I believe me, I understand that firsthand knowledge. How is what the trial court did here in this case different fundamentally from what happened in Faust?
Yeah, so I don't think Faust stands for the idea that the trial court cannot be involved at all in the stipulation discussion. Yeah. So the trial court was very concerned here with making sure that it was a voluntary agreement. He said explicitly multiple times to defense counsel, this needs to be voluntary. He gave defense counsel several opportunities. I believe defense counsel spoke with the client at least twice, I believe, for sure. One time was after the recess. And I think a lot of the confusion that the defendant points to here is from whether they were going to bifurcate or sever. So the context in which this came up was defense counsel, one of the motions that they filed the week before trial, along with the other ones, was a motion to bifurcate. So defense counsel was seeking bifurcation, and then they got there, and the trial judge was like, you know what, I think it's just easier if we just sever it and don't have to worry about it at all. But there was a lot of back and forth discussion over how best to handle it, how best to proceed, and
And the trial court directs the state to draft the stipulation, directs the state to present it. As your friend on the other side suggests, even after the stipulation is entered, defense counsel still doesn't know what it encompasses. I'm not really sure why, but she's still raising the issue. So how about this? Let's, just for sake of this question, let's assume that the court believes, I'm not suggesting this is the holding, let's suggest the court believes that the procedure by which the stipulation was arrived at is not different than Faust and was improper. What's the remedy?
well, assuming the court came to that conclusion, I think any error would have certainly been harmless here. You know, the defendant's primary concern was that the details of the defendant's 5 convictions not come in. She did not want any of that, any details about that to come in, and that is exactly what they got. They got a stipulation to the status. There was nothing before the jury about how many convictions he had, no details about those convictions, and, you know, they essentially got exactly what they asked for. And even at trial, when they entered the stipulation, the prosecutor also entered a brief video of the defendant admitting that he had a conviction, and defense counsel asked for a sidebar and came up and said, you know, we already stipulated to this, why is this coming in? So any error was certainly harmless, and the only real alternative would have been for the state to introduce those certified copies.
Okay, thank you, General, thank you.
Absolutely. So if they're turning briefly to the suppression issue as well, the defendant here waived his claim by not arguing it before the trial court. And I think the context in which the suppression issue came up is important. The court turned to it right after addressing the motion to continue, in which they talked about this advanced auto parts video, which was a lot, they wanted that video for the suppression hearing. And so they had gone through kind of the seizure and how everything played out. And there was no real dispute from the state that he was seized immediately or that officers pulled their guns. And within the context, they had just been talking about all of this. They turned the motion to suppress, and defense counsel just keeps repeating, well, he was seized. And the trial court appears to be trying to get her to make an argument of, why does this matter that he was seized? Like, everybody agrees that he was seized. And she just keeps repeating that and never says anything else. And so then the trial court just says, okay, well, we're just going to go to trial then. And to the extent there was any error here in not holding a hearing, it was harmless because this court can look to the trial evidence, and it is clear that they had probable cause to seize the defendant. The school resource officer testified that he saw the defendant sideswipe multiple cars. He was driving nearly double the speed limit, slid off the road, ran red lights, all of these things. And then when officers arrived, he was on the phone slurring his speech. They could smell alcohol coming from the car and saw the gun. So the arrest was certainly supported by probable cause.
Should the trial court have given a hearing, though?
I don't believe in this instance a hearing was required. I think, you know, this court has held previously that simply filing your motion is not sufficient, and you have to then pursue it and request a hearing. And this was an untimely motion. Defense counsel never really tried to make any argument, never requested a hearing, so I do not believe it was error, no. And if this court has no further questions, we ask that you affirm. Thank you.
Thank you.
Your Honor.
Yeah.
I failed to capture the amount of time of rebuttal.
3 minutes.
Thank you, sir.
Sure.
With regard to the harmless, as to each of these issues, the court in Faust, my understanding of Faust, and I was trying to look it up very quickly, was that this could not be harmless because of what we were talking about, that error was harmless with respect to the firearms conviction because the state is required to establish beyond a reasonable doubt these underlying elements of the offense. And that's what the court, they said was harmless as to everything else in Faust, but not to the firearm conviction, which would be the exact same posture we're in here. It can't be harmless. And I think that's what the Faust court said.
Hey, the stipulation, if I remember correctly, the stipulation said that your client had prior convictions, prior qualifying convictions. Is that correct?
That satisfied the statute subsection.
Okay. And you're saying that the stipulation, okay, now I want to make sure I understand what you're saying, where the stipulation failed in regards to the elements.
It was improperly entered. And so because it was improperly entered, the court in Faust said it can't be harmless. It's harmless as to everything else. There's plenty of proof, but this is the only proof as to those prior qualifying convictions, and therefore it can't be harmless.
So what the stipulation should have said is the convictions were for crimes of violence or for...
No, it doesn't have to do with the wording. Only the entry is our argument. It was improperly entered under Faust, and therefore there is nothing else, and it can't be harmless.
You're saying it's reversible per se because basically an element of the offense that the state carries the burden of proving.
I think that's what this
is
court
being forced
held in
on the
Faust.
defendant.
Yes,
It's
that's exactly right.
it's a structural error? Even though defense counsel proposes a stipulation, agrees to a stipulation, there is nothing substantively wrong with the stipulation. And unlike Faust, it doesn't affect any other charge.
If
That's
it's
a structural error?
If it's improperly entered, it's the equivalent of, yes.
Okay.
And with regard to the suppression, the state suggests that there's all these other reasons that whether we had a hearing, we've got all this in the trial that comes out. But what we don't have is what the first officer on the scene, who everybody accepted, seized him upon pulling in behind him. There's nothing, we don't know anything of what he knows, whether or not he has any probable cause, any facts. There's the police team doctrine. We don't know that he's been told anything. As far as I can tell from the record, there's nothing in the record that would support a warrantless seizure based on the record of the trial.
And that's all well and good, but I think it still goes back to, the question is, what responsibilities does defense counsel have to make sure that this gets heard? I mean, it's a late filed. Judge just says, look, we're going to trial. And nothing else is really done about it. And that's where, you know, I think this idea of putting it on the judge is the one that's going to have to go through and make sure everything is ruled on, is misplaced.
I understand the court's position for sure. And but I would just say that both the judge and the defense lawyer are responsible under Rule 12 to make sure that the rights of the defendant are protected.
Thank you, sir.
Thank you.
Thank you both. Thank you.
Thank you, counsel.